Well, hello there and welcome once again to the Employment Law Show. John Scholes here along with Lior Samfiru, employment lawyer. Obviously, you want to reach out to Lior anytime. We'll give you that contact information right off the top, 1-855-821-5900, help@employmentlawyer.ca. And there's a very nifty website, which is free and anonymous for you to use anytime, called pocketemploymentlawyer.ca. We'll drill down a little deeper on what that website offers and some of the tools available to you anytime, but I'll tell you right off the top. Severance pay calculator. The severance calculator is baked into pocketemploymentlawyer.ca. We will refer to that several times during the show. Maybe get to a couple of phone calls from our live radio show. We do that across the country. Go to employmentlawyer.ca. Find a station close to you that carries our hour-long show from pretty much coast to coast. And you can even call in, and your call may possibly end up on air sometime if it's good and something worth talking about for sure. So that's all coming up, and the main topic is things you should know when you lose your job. That's a little while, but Lior, we always start off with the week that was. Get us all primed up. What do you have for us this week, sir?
Well, Johnny, great to be here. Excited to always talk about employment law, and excited to inform as many of you as possible. If you're tuning in for the first time, what is this all about? Well, the description is in the name. It's the Employment Law Show. We're here to talk about your workplace rights, to inform and educate you so that when you have a workplace problem, you know what to do. You're not wondering, you're not having to run over to Google and try to find out a solution. So by watching the show, you'll learn about your severance if you lose your job. You'll learn about whether you can lose your job. You'll learn about human rights, discrimination, harassment, constructive dismissal. You name it, we cover it all, and it's for your benefit so that you know. So you're not like, unfortunately, the majority of the population that is still trying to understand their workplace rights. You will know. And of course, if you ever need further clarification or actual help to resolve those workplace issues, we'll give you my contact information in the office so that you can reach out and we can have a private chat. But now that we know what we want to do, let's do it. I always like to start off with the situation that came across my desk. Now, John, we've talked on the show before about the duty to accommodate. Yep. We've talked about the fact that an employer cannot discriminate someone because, let's say they have a medical condition, and they have to provide that employee with support, help, and accommodation. Well, this particular matter that came across my desk arose in a bit of a different context, so I think it's important to mention it. I spoke with a gentleman who was offered a promotion in his workplace, and he was very excited about it and told his employer he wants that promotion. So his employer, for its own reasons, wanted him to complete or for his doctor to complete a functional abilities form before the promotion was finalized. So the doctor completed that form, and it turned out that this person does have some physical limitations, but should still be able to do the job just fine. His employer gets that form and says, no, we're not going to accommodate you. We're not going to be able to give you the promotion in light of your physical limitations. Sorry, we'll see what happens in the future. Well, very upset, he calls me and he wants to know, is this right? Wrong. It's not right. It's not legal. The duty to accommodate applies here as well. To the extent that he couldn't necessarily do all the functions of this new job, the promotion, his employer has to accommodate. Maybe eliminate some portions of the job or give him additional support to do that. This was not a situation where there's no way he could do the job. So they had to accommodate. The fact that maybe it would have required some extra work, even some expense on behalf of the employer, does not mean they can say, no, we're not going to accommodate. They have to. That duty to accommodate is very serious. So by refusing to now give him that promotion because they would have otherwise had to accommodate, that's a human rights violation. That could also be a constructive dismissal. It's illegal. So here's what I'm going to do for him. I'm going to write a letter to that employer, and I bet you once they hear from me, all of a sudden they change course with respect to this accommodation, and now they'll be willing to do that because I called them on it. But I wanted to remind everyone there about this duty to accommodate. It's important. If you have that doctor's note, your employer has to accommodate.
This one didn't sound like it was too big an issue. I mean, we don't know. He didn't say the details about what accommodation this employee needs, but is the threshold not very high for an employer when it comes to just turning around and saying, I can't do it, my hands are tied, I'm out of resources?
Exactly. It is a very high threshold, and that is the key here. So it's not enough for the employer to say, well, if we accommodated you, it's going to be difficult. That's not enough. It has to be so difficult that just makes it almost impossible, costly. The employer would have to create things that it doesn't have. Yes, sure. They don't have to go that far. But, John, I find that in most cases, employers just don't want to go far enough. And that's a failure to accommodate, and our human rights laws do not look favorably on that.
Same rules apply for like a mom and pop shop as they would to a big, multinational?
Well, the law is the same, but the reality is that a mom and pop shop is going to have a lot less resources available to it than a bigger company. So as a practical matter, a larger company with people, resources, and money is going to have to really work harder to accommodate than a smaller shop, and it's going to be very difficult for the larger company to say, oh gosh, that's just too difficult.
As I mentioned off the top, anytime you want to catch one of our radio shows, it's been almost a decade. This March, actually, it'll be, this winter's going to be 10 years we've been doing those. You can go to employmentlawyer.ca and find a station near you. Once you find one, you can actually call into the show. We'd love to get you on the show talking to us. Call in, ask your questions. It might get cherry-picked. We play them back here, Lior, as you know, and we dissect them a little bit, so we'll get to our first phone call for the show right now.
I was recently on sick leave. I came back to work. 3 weeks into my return, I noticed that I was no longer invited to meetings. My responsibilities were disappearing. 58. I was a customer service manager. I've been there 8 years. I was let go. They did not give me a reason.
So before we even talk about what she is owed as a result of her termination, I have major concerns, and you're not going to be surprised to hear me say that, the fact that she was let go coming back from a sick leave, from a disability leave. Because if her employer simply says, you know what, we just don't really think she's reliable, we're not going to hire her back because we don't want her to go back on another disability leave, that's a human rights violation. You can't do that. You can't let someone go because they took a disability leave. So right off the bat, we may be looking at a human rights violation here. Obviously, we need to know more. But even if we put that aside and park it just for a little bit, the reality is she's owed severance, of course, and if she's still not at optimal health, that may mean even more severance than usual. So the question, of course, becomes, well, how much severance should this person be getting? You know what I'm about to do. I do it on every show. I'm going to go show you how to calculate that severance, and we're going to use our severance calculator. You can find it at pocketemploymentlawyer.ca. Again, it's pocketemploymentlawyer.ca. Let's do that right now, and let's see what we get. So we know that this person is a customer service manager, been there for 8 years, 58 years of age. You see she's owed as much as 14 months of severance, 14 months. Hopefully that is enough time, John, to allow her to find another job. That's the purpose of severance. But this, I think, also disqualifies and completely abolishes that myth that, oh, it should be a month per year of service. So it's not 8 months. For her, it's right around 14 months. Same with you at home. If you lost your job, are worried about losing your job, you're probably owed a lot more than what you've been offered or what you think you're owed. That's why you have to go to pocketemploymentlawyer.ca and use our severance calculator.
In addition to being a lawyer, radio show host, TV host, Lior also does a ton of YouTube and YouTube streaming. On Facebook is why you want to join one of those live streams, those chats. ST Lawyers, at ST Lawyers, to join in on one of those. First one for today, Lior, goes like this. Says, how should an employee who has made repeated mistakes and bad judgment calls over the years be let go? Are there steps that should lead up to the termination? I'm assuming this is probably an employer asking this question, right?
Yeah, it's a question from an employer. So if the employer is willing to pay the employee severance, they don't need to do anything. They can just let the person go, and whether or not what the employee did is bad or not doesn't factor in because severance is paid. Remember, an employer can let an employee go for most reasons, but they have to pay full severance. But in this situation, if the employer is unhappy with the performance and they want to terminate for cause, they want to not have to pay severance because they're saying, well, this person is not a good employee, makes a lot of mistakes, etc. So what does the employer do? Well, they build a case, and the good way to do that is to provide advance warning. So employee, you made this mistake, you have to stop, or there's going to be further discipline. Maybe the second time, employee, you have to do this, or else there's going to be additional discipline. And after 3 of those warnings, if the employee's conduct continues, then and only then can the employer consider terminating for cause and not paying severance. But you can't terminate for cause if you're an employer unless you've done that homework, unless you've built that case. You can't go from 0 to 100 just like that. You have to build your case. And for employees, just because you did something wrong, maybe you did a few things wrong, does not mean you can be let go without severance. It's very, very difficult to terminate you for cause without severance. In many cases, John, that's a wrongful dismissal.
In your history of 20 years almost of doing this, you find the trigger gets pulled far too early when it comes to that sort of thing, right?
Almost always. Yeah. Almost always. So unless the employee did something terrible, like they hit someone, they stole, they committed fraud, In most cases, what the employee did is not so bad that they can just be terminated for cause, and employers jump the gun all the time. They don't want to put in the work to build the case. And again, as I said, that results often in a wrongful dismissal case.
Short break coming up here, what you need to know if you've recently lost your job. We'll get to that. In the meantime, the phone number 1-855-821-5900. Want to reach out through email, you can do that as well. help@employmentlawyer.ca. We'll continue lots more of the Employment Law Show. It's coming right up. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Employment Law Show. John Scholes, and of course with Lior Samfiru, reaching out anytime by the phone, 1-855-821-5900, help@employmentlawyer.ca, or just employmentlawyer.ca, the website you want to go to. And there's also handy, absolutely free and anonymous pocket employmentlawyer.ca. In fact, you can go there even before you make that phone call. So much to be learned, and included in that is the severance calculator. But let's get into our topic for today, Lior. That is things you should know when you've recently lost your job. Number one, you can be fired for any reason as long as that reason is not discriminatory.
Usually when people call me after they lose their job, John, they're concerned and upset about being let go, and they often feel that they were let go for an improper reason, or that the employer shouldn't have let them go, should have kept them on longer, maybe should have let someone else go if someone had to go. And I understand that. And I kind of, as a human being, I sympathize and I get it, and I would feel the exact same way. But we have to put our legal hat on here. And the reality is that from a legal standpoint, an employer can generally let you go for any reason or for no reason, as long as they have to pay severance. And you say, well, wait, how is that fair? The answer is it's not. It absolutely is not fair. But the question is it legal? And it is. So as long as your employer is not discriminating against you, you can't be let go for a discriminatory reason. You can't be let go because of your age or ethnicity or disability or because you need accommodation. But as long as the reason is not otherwise a human rights violation, usually your employer can let you go, but they have to pay you severance. Now, oftentimes, an employer lets someone go for legitimate reasons. So in other words, not illegal reasons, but where they make the mistake, where it becomes illegal, is not paying proper severance. So that often is the focus. That's why we spend so much time on this show talking about severance. But yeah, you can be let go as long as severance is paid. Point number two, when you lose your job, you got to know this: you cannot be pressured or forced to resign. Very important. And oftentimes employers say, well, we know how to save money in severance. Why don't we just tell the person to resign? Aren't we smart? Now we don't have to pay severance. Well, it would be smart if you just resign, for the employer, if you resign, because they wouldn't have to pay severance, which is why you don't do that. You cannot be legally forced to resign. By definition, a resignation is something that you, the employee, do voluntarily. You can't be told to resign, made to resign, forced to resign, whatever the right word there is. So no, if your employer wants you gone, they can let you go. And if you're ever told by your employer, we need you to resign, your answer should be no, I'm not. I'm going to continue working until you, employer, tell me to stop, unless you, employer, let me go. It's not better to resign. By resigning, not only do you not get severance, you wouldn't get EI either. So do not resign unless you want to, unless it's your decision. You cannot be forced. Is there ever a situation where it might be better for you to pull the trigger on your own employment and resign? Like if you've stolen something and you know it, right? Well, certainly, if you've stolen something, yeah, you're not going to get severance. You're not going to get EI. May as well resign. But there's other situations. We've talked about that before. Maybe your job has changed significantly. Let's say your pay is reduced. Right. You're better off resigning and treating that as a constructive dismissal. But in the eyes of the law, that's still a termination. That's your decision, but not to be forced to do so.
We're talking about things you need to know if you were recently let go from your job. Super important. Number 3 is this, Lior. If you were let go for cause, you're likely still owed compensation despite what your employer may have said.
And we touched on that before the last break. And what an employer often does, and I do mean often, John, is they say, well, here's all the things you did wrong, Mr. or Mrs. Employee. So we're going to let you go for cause. We're not going to pay you any severance, or maybe we're going to be nice and offer you 1 cent on the dollar. Well, no, not so fast. Not everyone is a perfect employee, John, okay? But just because you were not a perfect employee, maybe you made some mistakes, maybe you did some things you wish you could take back, fair enough. But the fact that you did those things does not mean that it rises to the level of cause. It is very difficult to terminate for cause. Your behavior has to be extremely serious for that to actually be cause. And there's nothing in between. Either there's cause at 100% or there's no cause at all. You can't be 75% cause. And because of that, because it's so difficult to terminate for cause, when an employer does say it's cause, often it's not. And because of that, you're owed severance. And that severance, even with not so great behavior, can be as much as 24 months' pay. So if you're let go anytime, but especially if your employer says it has cause, you have to give me a call.
Number 4 thing you need to know is this: you do not have to sign the termination letter by a deadline or when that employer says, you know, Friday at 5, we need it back to us, get it done, get it done.
Every single time someone is let go, they receive that termination letter, anywhere from 2 to 10 pages long, there's going to be a date on it by which your employer wants you to sign it. There's going to be, usually they give you anywhere from 2 to 4 to maybe 5 days on the high end, and you'd feel that pressure. Most people would. Oh my gosh, they told me I have to accept this by Friday or I'm not going to get it, so I better rush over, get my pen, sign it, and return it. No, not so fast. Your legal rights don't expire on that Friday or whatever the deadline is. What your employer is offering you is likely a lot less than what you're actually owed, but they're hoping with that pressure tactic that you'll accept it. You now know better because you're watching us now, so do not sign that by the deadline. You're not losing anything, you're not missing anything. The only thing you're doing is ensuring that you're not taking less than what you're owed. Go to pocketemploymentlawyer.ca, use our severance calculator, or just give me a call. We'll get you what you're owed because that's what the law does. That deadline is meaningless.
You got 2 years, right? No, nobody takes 2 years, I would imagine, but you have 2 years.
I wouldn't recommend taking 2 years, but you can, and your legal rights don't expire for that period of time. They certainly don't expire Friday, so don't worry about that deadline.
We're talking about things you should know if you've recently been let go from your job. Point number 5 kind of piggybacks on number 4, and that is you should not accept a severance offer before getting legal advice from an employment lawyer like you. Do not do it.
You know, my calls that I get that I hate the most, and I cringe when I get those calls, unfortunately happens often, is when people call me after they've accepted and they realized after the fact that, wait a second, I was owed a lot more. And sometimes they call me with stories saying, well, I was under so much pressure and stress. I signed it. I really wasn't thinking clearly.
Then I saw your show.
Yeah, I saw your show, or someone told me, or maybe I had time to digest what happened. Yeah. And they want my help. Unfortunately, I can't. I cannot help you once you've signed that letter. Even though I know you felt the stress, the pressure, that anxiety, I get that. I see it all the time. You cannot then go back, unfortunately. You have one opportunity to do this right, to get what the law says you should have. And to use that opportunity, you cannot sign that offer. I get the pressure tactic. I know the anxiety, but you still have to do the right thing. Call me. Let's talk about what you're owed. Let's talk about how to get it. It's not complicated. It doesn't take long. It's not expensive. So let's do the right thing and not accept inadequate severance.
We always tell you to go to employmentlawyer.ca for many reasons, but also to find a radio station across the country that takes our long-running radio show. All kinds of opportunities during those hour-long shows to call in and ask your questions, right? Phone call number 2 from our radio program coming up right now.
My new manager is trying to revise our schedule. According to him, he doesn't work the late nights. So now my colleague and I have to do the late nights to fill in for him. So I'm just curious because my personal schedule is set around for the last 5 years, and they want us to change like next week.
Mm-hmm. So if her schedule has been consistent for years, if she knew what her schedule was and now her employer wants to change it in a significant way, they can't do that. They don't have the ability to force that. And her refusal to change her schedule that way, is not going to give the company grounds to let her go for cause. So she can say, no, I'm not doing that. And if the employer tries to impose it anyway, that could be a constructive dismissal. But here's what I want you to keep in mind. Remember what I was saying just a few moments ago, that your employer can let you go for any reason, right? As long as they pay severance. So her employer may say, well, you didn't agree to this new schedule, I'm letting you go. Severance will absolutely have to be paid here, absolutely. But the employee still has to decide ultimately, is she better off doing this change, accepting the change, or leaving potentially with her severance? But no, can it be imposed on you? Absolutely not. If your schedule has been fixed, your employer can't just unilaterally make significant changes to it.
Does an employer have a little bit of wiggle room sometime? Obviously, going from days to nights is extreme, but it's like instead of working 9 to 5, you're doing 8:30 to 4:30, somewhere around there. Can they do that, or is that still no, no, no?
There is flexibility. It comes down to, is it a significant change? And of course, what is considered significant is going to vary from case to case and employee to employee. So yeah, 9:30 or 9 to 5 to 8:30 to 4:30 is not going to be significant. Days to night, always significant. And of course, there's a lot of types of changes in between. They may or may not be significant. So if you're not sure if your change is permissible, is it too significant, just call me and we'll talk about that specific situation.
Another question we're going to tackle in a moment. Can you be refused a reference by a former employer? That is on the way after a short break. Here's the number to reach out in the meantime, 1-855-821-5900, help@employmentlawyer.ca. We'll continue. This is the Employment Law Show. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back, Employment Law Show. So good to have you along for the half hour each week. John Scholes here and Lior Samfiru, of course, employment lawyer, reachable at 1-855-821-5900, help@employmentlawyer.ca. Radio shows across the country. Go to employmentlawyer.ca to find one. Listen to back shows as well. Tune in every week, maybe make a phone call, get inside the show, become part of the show as well. Phone call number 3 from our long-running radio shows. Lior's coming up right now.
Was called into the office due to restructuring. I believe the severance was about a month a year. My position was like senior property manager. If I didn't accept it, that they would be compelled not to provide as good a reference to subsequent employer.
How long have you been working there?
3.5 years.
And how old are you?
52.
Is that a huge deal, a reference? I mean, it's something you work into when you deal with a former employer. But.
Well, certainly for an employee, you would want a reference letter because it may be difficult to explain to a new prospective employer, why couldn't you get a reference letter? And that just may make it look bad when you're looking for another job. And here's the thing, this is why I think an employer that does this is, I'm going to use stronger language, is just dumb. And here's what I mean by that. An employer that lets someone go wants that employee to find another job as quickly as possible. Because if that employee finds a job very quickly, that may reduce their severance obligations. So by not giving them a letter of reference, you make it harder for them to find another job, which means you have to pay them more severance. So that's why it's really, really dumb for the employer to keep the letter of reference hostage. What I would say to an employer, you give them the letter of reference immediately. It doesn't matter if they sign, they don't sign. You want them to give a letter of reference. You want them to have it. You want them to find another job. Now, of course, whenever we negotiate severance packages for our clients, we always negotiate a letter of reference as well as the name of a person that can give a verbal reference. That's important. So we want that. Yeah. But the real question, of course, here is also this. Whether or not this person, after 3.5 years, he was offered right around 3 months severance, is that enough? And a lot of people may say, well, yeah, that sounds right. It's a month per year. So that's not bad, right? wrong. Okay, I hope our regular viewers know what I'm about to say. It's wrong. So we're going to go right now to our severance calculator, which you can find at pocketemploymentlawyer.ca, and let's see whether he gets really a month per year or maybe something else. So property manager, 3.5 years of age. I said maybe he's 52 years old. He was offered 3 months, kind of a month per year. You see there he's owed 6 months. So that's 2 months per year. That's double what he was offered. John, double. That means 100% increase, okay? That's what he's owed, and that's why it's so important that you understand that you have significant severance entitlements, and the best place probably to start, grab your smartphone, use our calculator at pocketemploymentlawyer.ca.
Another way for you to ask questions anytime for Lior and the rest of his team is terminationquestions.com. Again, free and anonymous. Just type your questions in there, and they'll get answered pretty quickly. Here's one for this show. Lior says, I work for a large manufacturer that is unfortunately shutting down operations. I think I was offered a good severance package, but it doesn't include my bonus and overtime pay. Is that normal?
So very important. Great question. I love that question because when we do the show, we often talk about the number of months that someone is owed. Yep. 6 months, 12 months, 24 months. And of course, that's important. But we cannot forget that we have to also ask ourselves, well, what's included in those months? So what's included has to be all components of your compensation. So your salary, of course, but your benefits, your bonus, overtime, average overtime if you work regularly, car allowance, pension contributions, those could be huge. Right. So everything has to be included. If you want to know if something needs to be included, you ask yourself a simple question. Would I have gotten it had I continued working? If the answer is yes, I would have, well, guess what? Then it has to be included as part of your severance. So if this person says, I think I got a good severance package, but it doesn't include my bonus and overtime, by definition, it can't be a good offer because it's not what he's owed. He is owed his average overtime. He's owed his bonus. By the way, bonus would be both the accrued bonus year to date and on a go-forward basis. So there's two aspects to that bonus. So all components of your compensation, and if you don't get that, guess what? You're owed more.
Got time for a quick email question before we wrap for the show. Lior says this, my wife is currently on maternity leave, scheduled to return in the spring. She was recently notified that her position is being eliminated, and the only option offered her is a 6-month contract position. What are her rights at this time?
Well, how does the employer know now that they're not going to have a job for her months from now when she's ready to go back to work? They can't know that, and that's important because an employer has the obligation to bring an employee back from parental leave. And the only way they can to figure out if they can meet that obligation is at the time she's ready to come back to work. And clearly there is a job. They're offering this other contract. So right off the bat, I am very concerned that this is a human rights violation. This is an employment standards violation. There's very, very little wiggle room when it comes to parental leave. If you've been on parental leave, your employer has to bring you back. Same job, same pay, same hours. If the job's pay has increased in the meantime, they have to pay you that increased amount. And there's very, very little that the employer can do to avoid that. So it certainly seems to me like that's a problem. This is not what this employer is doing here. There's a potential violation here. So this person needs to connect with me personally so we can get to the bottom of it.
I guess unless they're shutting the whole department down, that's a different thing, right?
Well, listen, if I'm ready to come back to work from parental leave and I worked in the department with 10 people. Now everyone's gone. They shut down the department. Yeah, absolutely. Then I'm going to be let go and I'm owed my severance. But other than that extreme situation, the employer can't say, well, we gave you a job to someone else. Too bad. You have to bring that person back to work with their full pay, even if it means taking away or taking out that person that was doing the job while the other employee was on parental leave.
In a nutshell, don't mess with mom and dad. We've been saying that for years on this show, right? Just don't do it.
We're going to put these on these mugs at some point here in front of us. It's a good way to remember what the law is. It's serious. And even these days, John, I get way too many calls and questions from people in exactly that situation where the employer is not treating them properly coming back from parental leave.
All right, good stuff. We are done for another show. Thank you so much. Reaching out now that we are done, 1-855-821-5900. Use the number anytime. help@employmentlawyer.ca. And that website, go there first, pocketemploymentlawyer.ca. Severance calculator is there as well. We'll catch you next time on the Employment Law Show.